Number 10. The Laws of Manu, ancient India's legal architecture of womanhood approximately 2,000 years ago. Though the oral traditions it codified are older, a Sanskrit legal text called the Manusmriti was composed. Scholars also call it the Laws of Manu. It is one of the most comprehensive legal and social codes in the ancient world. It is also one of the most detailed legal documents ever written on the subject of controlling women. The Laws of Manu did not simply restrict women in one area of life. They structured the entire arc of female existence, from infancy to death, under a principle that is stated explicitly in the text itself. A woman should never be independent. In childhood, a female must be subject to her father. In youth, to her husband. When her lord is dead, to her sons. A woman must never be independent. This was not a cultural observation. This was law. The Manusmriti specified that a woman could not own property independently. She could not study the Vedic scriptures. She could not perform certain religious rituals without a male intermediary. If her husband died, she was legally prohibited in many interpretations from remarrying, and some passages endorsed the practice of a widow remaining celibate for the rest of her life as a form of legal virtue. The text assigned women a caste-adjacent legal status. Not quite a caste, but something that functioned like one, a permanent secondary legal category defined entirely by biology and relationship to men. Historians, including Wendy Doniger, Patrick Olivelle, and Robert Lingat, have spent decades analyzing this text. What they consistently find is that the Laws of Manu were not simply a conservative document. They were a sophisticated legal system, internally consistent, philosophically reasoned, and designed to function across generations. That internal consistency is part of what makes it disturbing. This was not carelessness. Someone sat down and thought carefully about every phase of a woman's life and wrote the restrictions for each one. What makes this particularly unsettling is not just its age. It is its reach. The Laws of Manu shaped Hindu legal tradition for over 2,000 years. British colonial administrators in India used it as a reference document when codifying family law in the 18th and 19th centuries. Its influence was not theoretical. It had consequences that stretched into the modern era. A woman born in ancient India did not simply live under the customs of her community. She lived inside a legal map that had been drawn before she existed. The map told her exactly where she was allowed to stand. She was never allowed to step off it. Number 9. The Athenian Kyrios System, the legal owner of every woman. Athens, the birthplace of democracy. The city that gave the Western world philosophy, theatre, science, and the concept of citizen governance. Athens also gave the world one of the most totalizing systems of legal female guardianship ever devised. The system was called the Kyrios. Every free woman in Athens was legally required to have one, a male guardian whose authority over her was not informal or cultural. It was enforceable in Athenian courts. From birth, a woman's Kyrios was her father. At marriage, it transferred to her husband. If her husband died, it passed to her son or to a male relative designated by the courts. A woman who had no male relative of suitable standing could have a Kyrios appointed by the state. What did the Kyrios control? Everything. A woman could not enter into any legal contract without her Kyrios. She could not buy or sell property above a very small threshold. Ancient sources suggest approximately 1 medimnos of barley in value, roughly enough grain to feed a family for several days. She could not appear in court as a plaintiff or defendant in her own right. She could not conduct business. She could not decide where to live. She could not arrange her own marriage or her children's marriages. What is particularly striking is how this played out in practice. Scholars, including Sarah Pomeroy, whose landmark work Goddesses, Whores, Wives, and Slaves remains one of the foundational texts on women in antiquity, noted that Athenian women were legally more restricted than the female slaves of some other ancient cultures. A slave woman in certain contexts could conduct minor business on behalf of her owner. A free Athenian woman could not do the equivalent on her own behalf. The irony is embedded in the word democracy itself. The demos, the people, did not include women. It never had. The democracy Athens invented was a democracy of men, for men, administered by men, in a legal world where women were perpetually represented by a male voice that was not theirs. What makes this disturbing is not simply the restriction, it is the invisibility. Athenian women were not legally erased in a dramatic way. They were simply never written into the legal system in the first place. The law did not say a woman cannot. It said a woman must have someone else who can. The effect was the same. An Athenian woman was a free person who could not act freely. She was a legal person who could not speak legally. She lived inside a democracy that had no word for her citizenship because it had never intended one. Number 8. The Middle Aegean Law, the most brutal legal code in the ancient world around 1100 BCE, the Assyrian Empire, centered in what is now northern Iraq, produced a set of legal tablets that were rediscovered by archaeologists in the late 19th and early 20th centuries. When scholars translated them, they found something that startled even specialists in ancient law. The Middle Assyrian laws contained some of the most explicitly violent legal provisions regarding women found anywhere in the ancient world. The veiling law alone is worth understanding in full detail. Assyrian law required married women and widows to veil themselves in public. That might sound familiar. What is less familiar is the penalty structure. Unmarried women and prostitutes were legally forbidden from veiling. If a prostitute was found veiled in public, she was to be seized, brought before a magistrate, and beaten 50 times with rods. Her clothes could be confiscated. She faced further punishment at the magistrate's discretion. The person who saw her veiled and failed to report her was also punished. What this law created was a legal system of visual classification. A woman's veil was not a choice. It was a legal status marker. The wrong woman wearing it in the wrong place was a criminal act, and any man on the street was empowered and legally obligated to enforce it. The tablets also contain marriage provisions of extraordinary harshness. A husband could legally beat his wife, pull her hair, bruise and mutilate her ears, and the text specifies this required no legal justification. He owed no explanation to any court. If a woman struck a man during an argument, her punishment included having one of her fingers cut off. If she struck him a second time, both lips would be burned. Assyrian law also addressed the dissolution of marriage with clinical brutality. A husband who wished to divorce his wife could simply send her out of the house. She left with nothing unless the husband chose to give her something. If she had children, the children could remain with him. The scholar Martha Roth at the University of Chicago, who produced once one of the most authoritative translations of the Middle Assyrian laws in the 20th century, noted that the Assyrian code was notably harsher in its treatment of women than the Code of Hammurabi, which preceded it. Something had moved backward. What makes this particularly terrifying is what it reveals about legal history. We often assume that legal systems progress, that the further you go into the past, the cruder the law. The Middle Assyrian laws contradict that assumption. They are detailed, sophisticated, internally consistent, and catastrophically cruel. Someone wrote these laws. Someone read them aloud. Someone enforced them on the bodies of real women who Number 7. Roman patria potestassa, father's legal power of life, and death. Rome built an empire. It also built one of the most sophisticated legal systems in the ancient world, a system so influential that its principles still appear in the legal codes of France, Spain, Italy, and much of Latin America today. Embedded within that legal system was the patria potestas, the power of the father. Under Roman law, the pater familias, the senior male head of a Roman household, held a legal authority over every person in his family that had almost no equivalent in the ancient world. His power was not simply financial or social. It was legally recognized as extending to life and death. A Roman father could legally kill his child, including an adult child. He could legally sell his children into slavery. He could legally arrange, dissolve, or veto any marriage. In early Roman law, he could legally expose an unwanted infant, and the law specifically instructed that daughters were more likely to be exposed than sons. For Roman women, the patria potestas meant that they lived their entire lives under male legal authority. A daughter was under her father until she married, at which point she passed into the manus, the legal hand, of her husband, her legal identity transferred with her. This is not interpretation. The Roman legal scholar Gaius, writing in the 2nd century CE, stated explicitly that women were in a position of perpetual tutelage, tutela, because of their supposed weakness of intellect. This was not bigotry expressed as custom. It was bigotry written into the formal legal reasoning of the Roman state. Later Roman law did introduce reforms. By the classical period, manus marriages, where a woman passed entirely into her husband's legal control, had become less common. Some women of the upper classes gained a form of legal independence called sui juris, particularly if their fathers had died and they had no male heirs. But these were exceptions navigated within a system still fundamentally organized around male legal supremacy. The scholars Jane Gardner and Susan Treggiari have both written extensively on this. What they find is not a legal system that simply excluded women. It is a legal system that was actively organized around the premise that a woman's legal identity was always contingent on a man's. What makes this unsettling is the reach. Roman law did not die with Rome. It was preserved, studied, and reapplied by the Catholic Church, by medieval legal scholars, and by the legal architects of modern European states. The tutela, the legal tutelage of women, survived in various forms in European law until the 19th and 20th centuries. The empire fell. The legal logic did not. Number 6. The Code of Hammurabi, Babylon's price list for women. The Code of Hammurabi. Carved onto a basalt stele nearly 8 feet tall, discovered by French archaeologists at Susa in 1901, now held in the Louvre, dated to approximately 1754 BCE, one of the oldest and most complete legal codes in human history. It is also one of the most explicitly transactional documents ever written about women. The Code of Hammurabi contains 282 laws. A significant number of them deal with women, not as citizens, not as persons with independent legal standing, but as objects of legal transaction between men. Marriage in the Code of Hammurabi was a commercial contract conducted between a man and a woman's father. The bride price, the terhatum, was paid by the groom to the bride's family. This was not a gift. It was a legal payment that formalized the transfer of the woman from one male household to another. If the groom died before the wedding, the code specified that his bride price must be returned to his family, not to the woman herself. She was not a party to the transaction. She was its subject. Law 138 of the Code states that if a man wishes to divorce his wife who has not borne him children, he must return her dowry and pay her a sum equivalent to 1 mina of silver. Law 141 specifies that if the wife has been going out of the house, neglecting her house, and belittling her husband, and this is proven in court, that man may divorce her without giving her anything. The asymmetry is precise and deliberate. A man pays to exit a marriage when he is at fault. A woman exits with nothing when she is found to have behaved in a way her husband disapproved of. The legal system measured female behavior and assigned financial penalties for it. The code also addressed sexual violence, but in ways that reveal the underlying logic. Law 130 states that if a man violates the betrothed wife of another man, who is a virgin living in her father's house, that man shall be put to death. But the focus of the law is not the violation of the woman. It is the violation of the property rights of the men around her. Her father and her betrothed, the woman is not a victim in the legal sense. She is the damaged object at the center of a dispute between men. The scholar Martha Roth, alongside others, including Tikva Freimer-Kensky, has written at length about this. What they consistently note is that the Code of Hammurabi represented a sophisticated legal imagination, and that imagination saw women primarily as economic and reproductive assets to be managed, protected from damage, and transferred between men. What makes this moment so significant is not that it is barbaric, it is that it is foundational. The Code of Hammurabi is not a dark footnote in legal history. It is the opening chapter. These assumptions did not vanish. They were inherited, modified, and passed forward into every legal tradition that followed. The stele is beautiful. The law it carries is a record of a world that decided, in writing, what a woman was worth. Number 5. Ancient Egyptian exception, and why they make everything else worse. Ancient Egypt is the outlier. In a world where almost every major civilization produced legal codes that treated women as legal dependents, ancient Egypt offered something different. Egyptian women, at least those of free status, had a legal standing that would not be matched in most of Europe for another 2,000 years. An Egyptian woman could own property independently. She could inherit. She could buy and sell land. She could take out loans and enter into contracts. She could sue in court and be sued. She could testify as a witness. She could initiate divorce. These are not minor permissions. These are the fundamental legal capacities that define a person as a full participant in a legal system. Egyptian women had them. Papyri recovered from ancient Egypt, including those from the Ptolemaic period, roughly 300 to 30 BCE, document women conducting complex legal transactions. Women appearing in court, women negotiating land transfers, women writing their own wills. The Egyptologist Janet Johnson at the Oriental Institute of the University of Chicago has spent decades documenting this, producing detailed analyses of the legal status of women in ancient Egypt. What she found was a legal culture notably distinct from its contemporaries. But here is why this sits at number 5 on a countdown about disturbing ancient laws. Egypt's relative progressivism does not make the ancient world look better, it makes it look worse. Because if Egypt could imagine women as legal persons with rights and standing, if that concept was possible, achievable, and functional, then every other ancient civilization that did not imagine it made a choice. Babylon chose differently, Assyria chose differently, Athens chose differently, Rome chose differently, and even Egypt had limits. Egyptian women did not hold the highest religious offices in most periods. They did not dominate political governance. The pharaoh was almost always male. The legal rights women had in Egypt existed within a world still largely organized around male authority. What Egypt demonstrates is not that ancient peoples were incapable of imagining female legal personhood. It is that they were mostly unwilling to. The exception does not excuse the rule. It reveals that the rule was a decision, Tuber 4, Spartan women the law, that made them breeding assets of the state. Sparta is often cited, even today, as an ancient society that respected women, and by the standards of the ancient world, that is partially true. Spartan women could own land. They received physical training. They were not confined to the domestic interior the way Athenian women were. They could speak publicly, but here is what is important to understand about why Sparta gave women these things. It was not for the women. Spartan law and social organization were built around a single function, the production of elite soldiers. Everything in Spartan society, land, agriculture, the helot slave system, the agoge military training program, and yes, the treatment of women was designed to serve that military purpose. The physical training Spartan women received was not for their own strength or autonomy. It was because Spartan thinkers believed, and Plutarch records this explicitly in his Life of Lycurgus, that strong mothers produced stronger sons. The female body was understood as a vessel for military reproduction, and Spartan law organized itself around optimizing that vessel. The legal and social framework around Spartan marriage reinforced this completely. Marriages were often arranged for eugenic purposes, to combine strong bloodlines. Older men who recognized their own physical decline were sometimes expected to allow younger, stronger men to father children with their wives, so that the bloodline of the state would not be weakened. This was not a private arrangement. It was state-sanctioned. It was legally permitted and socially encouraged. Spartan law also did not give women genuine political power. The governing bodies of Sparta, the Gerousia, the Council of Elders, and the Ephors were exclusively male. Women could own land and manage estates, particularly because Spartan men were so often absent for military service. But that management was practical necessity, not a recognition of political equality. Aristotle, writing in his Politics, was critical of Sparta on precisely this point. He argued that Spartan women had too much influence, but even he recognized that the influence they had was economic and domestic, not political. What makes this disturbing is the inversion. Sparta gave women more freedom than most ancient societies and still reduced them to a biological and reproductive function of the state. The freedom was a tool. The woman was the mechanism. Being slightly less invisible does not mean you are seen. Number 3. Chinese Zhou and Han dynasty law. When women became legally invisible at marriage in ancient China, the legal and philosophical framework that governed female existence was rooted in a concept that became formalized across the Zhou, Qin, and Han dynasties. The 3 obediences: before marriage, obey your father; after marriage, obey your husband; after your husband's death, obey your son. This was not simply Confucian philosophy, though it was framed in Confucian terms. It had legal expression. Chinese family law during these periods was organized around a system in which a woman's legal identity merged with, and was subordinated to, that of the family she married into. Upon marriage, a woman left her birth family and entered her husband's family as a legal subordinate. She ceased to have independent legal standing in many matters. Her relationship with her own birth family was legally weakened. She belonged to her husband's household in a legal as well as practical sense. If she failed to satisfy the obligations of that household, she could be sent back. The Qiqiu, the 7 grounds for divorce, listed in ancient Chinese law, were exclusively applied to wives, not husbands. They included failure to bear a son, excessive talking, theft, jealousy, and disease. Failure to bear a son was listed first. The legal scholar Karen Turner, among others, has written about how Chinese legal codes formalized these Confucian principles into enforceable law, particularly during the Han Dynasty. What is significant is the mechanism. The law did not simply restrict women. It made the family unit, specifically the husband's family, the legal environment in which a woman existed. To step outside that environment was not just socially dangerous, it was legally precarious. The concept of female legal identity being defined entirely through relationship to male family members had profound consequences. A widow with no male relatives to mediate her legal affairs was genuinely vulnerable in the formal legal system, regardless of her own intelligence, wealth, or capability. What makes this entry disturbing is not just the restriction, it is the totality. At the moment of marriage, a woman did not simply take a new name or join a new household. She stepped out of one legal identity and into another, one defined entirely by someone else's family structure. There was no legal version of herself that did not belong to someone. Number 2. Roman law female testimony. The world where women could not speak in court under Roman law, the courtroom was one of the most important spaces in civic life. Legal disputes were adjudicated there. Crimes were prosecuted. Contracts were enforced. Political careers were made in the Roman Forum through legal oratory. Women could not participate in most of this. The formal legal principle was known by the Latin term incapacity. Women were, in many legal contexts, considered incapable of appearing in court as full legal actors. They could not be advocates. They could not represent others. In many periods and contexts, their testimony was treated as inherently less reliable than that of men, or excluded entirely. The legal scholar Gaius, again, is explicit about this. In his Institutes, one of the foundational texts of Roman legal education, he lists women among those who cannot perform certain legal acts because of their gender. This was not case law or judicial interpretation. It was written into the teaching materials of Roman law itself. The implications were devastating in practical terms. A woman who was the victim of a crime committed by her husband had extremely limited legal recourse, since she could not independently bring a full legal action. A woman whose property was taken from her might need a male advocate, her Kyrios equivalent, the Roman tutor, to bring the case. A woman who witnessed a crime might find her testimony treated as supplementary or inadmissible. Roman law did make some exceptions. Women could testify in certain matters, particularly those involving their own domestic affairs. In later Roman law, some of these restrictions were moderated, but the underlying principle that a woman's legal voice was structurally less valid than a man's persisted across Roman legal history. The historian Judith Evans Grubbs, whose research on women and the law in late antiquity is among the most detailed available, has traced how these restrictions shaped everything from property disputes to criminal cases. What she finds is a legal world in which female experience was routinely filtered through male interpretation before it could enter the official record. A woman could live through something and have no legal means to describe it. The court would not hear her. The record would not contain her words. Her experience would be reported by someone else, interpreted by someone else, judged by someone else. Think about what that means for the historical record. For 1,000 years of Roman legal history, the official version of events was a version from which female testimony was structurally excluded or discounted. What we know about life in Rome is the version the law decided we should know, and the law decided that women's voices were not a reliable part of that story. That silence did not end with Rome. European legal traditions inherited this principle. Female testimony was treated with explicit suspicion in medieval law. English common law contained provisions limiting women's testimony. Canon law, the law of the Catholic Church, applied similar restrictions. The legal silencing of women in Rome was not an ancient curiosity. It was the foundation of a tradition. Number 1. The silence law, how ancient civilizations made female voice itself illegal. Number 1. Every item on this list describes a specific law in a specific civilization: a property restriction in Rome, a guardianship system in Athens, a veiling code in Assyria, a marriage framework in Babylon. But number 1 is something different. Number 1 is the law that made all the other laws possible. The law that was never written in a single place because it did not need to be. It was written everywhere, across ancient Babylon, Assyria, Athens, Rome, China, and India. There existed formal and informal legal mechanisms specifically designed to prevent women from speaking with public authority, not just in courts, not just in political assemblies. In the construction of the official record itself, the Athenian Kyrios System meant that a woman could not address the assembly, could not serve as a legal advocate, could not enter into the civic speech of the polis. The Roman legal system excluded women from advocacy and limited their testimony. Assyrian veiling law regulated where women could appear in public at all, and what they could visibly claim to be. The Laws of Manu restricted women's access to religious texts and the ritual speech that accompanied them. Chinese law made female public speech a marker of bad character. One of the grounds for divorce was, literally, excessive talking. This was not coincidence. These civilizations did not communicate these ideas with each other in most cases. They arrived at the same legal conclusion independently. The conclusion was this: female voice, operating in public with authority, was dangerous to the social order, and so it needed to be legally managed. What that legal management produced was something far more powerful than any single law. It produced the historical record. Think about this carefully. The documents we use to reconstruct ancient life, legal codes, philosophical texts, historical chronicles, religious scriptures, court records, were almost entirely produced by men in legal systems that excluded women from the processes that produced those documents. The ancient world is not silent about women. It is loud about women. It describes them, regulates them, argues about them, prices them, controls them, but it is almost entirely silent in a different way. It contains almost no female voice saying, in her own legal words, "This is my experience, this is my account, this is what I witnessed, this is what was done to me." That silence was not accidental. It was constructed. Historians, including Mary Wiesner-Hanks, Gerda Lerner, and Joan Kelly, have all grappled with this problem from different angles. Gerda Lerner's landmark work, The Creation of Patriarchy, published in 1986, argues that the exclusion of women from literate culture and legal speech was not simply a consequence of patriarchy. It was one of its primary mechanisms. Control the voice, and you control the record. Control the record, and you control what future generations understand to be true. We are still living with that control. Every ancient law on this list, the guardianship systems, the property restrictions, the veiling codes, the testimony limits, the obedience doctrines, contributed to a world where the primary legal activity women participated in was being subject to law, not making it, enforcing it, or describing their experience under it. The most terrifying ancient law on women is not the one that set the price of a bride. It is not the one that allowed a husband to mutilate his wife's ears. It is not the one that required a widow to live in perpetual subordination to her son. The most terrifying law is the one we cannot fully quote, because it was never written in a single place. It was written in the structure of every legal system that came before us. It said, "Your words do not count. Your experience does not enter the record. Your voice will not survive." And then it worked. We are reading history right now. We are learning about ancient civilizations from documents that survive. And almost none of those documents were written by the women who lived inside the laws described in every number on this list. That is not a footnote. That is the story.